All right, the next case we have this morning is Michelle VELEZ versus the state of Florida. Would you like to reserve some time, sir?
Yes, Your Honor. I'd like 3 minutes if I may.
Just give counsel an opportunity to get herself organized and we'll get started. Ready? All right. Counsel, you may begin. Thank you, sir.
Thank you very much, Your Honor. For the record, my name is H. Manuel Hernandez, and I represent Ms. VELEZ in this particular case. On about July 1st of 2005, when this Ms. VELEZ was arrested, she was a deputy Orange County sheriff on maternity leave. She had just had a baby about 6 weeks earlier, and was.
Let me ask you something. I read your brief. I read it twice. I can assure you that we're familiar with the facts. It seems like a lot of that stuff in there is just information that is calculated to evoke sympathy. The baby and all that. What's the relevance of all that? I mean, it might have had an impact on the jury, but what's the relevance on that?
Your Honor, it goes to the issue of, particularly on the sufficiency of the evidence, and I'm going to address the double jeopardy, which I think is probably the argument I'd like to focus on, but on the sufficiency of the evidence.
How can you have double jeopardy if she was only convicted of one crime?
I was kind of curious about that myself.
There was a lesser included on the resisting with violence. This whole event took place in less than a minute, according to the testimony of Officer Toller. The state decided.
I understand your argument about it all arising from the same nucleus of facts and all that. And let's just say, for the sake of argument, that you're right about that. Isn't there, all kinds of decisional law, though, that says that the state essentially can charge them with two crimes, and then make the election after the verdict comes in as to which one they want to proceed on, and it's not a double jeopardy violation until there's a judgment adjudicating the defendant guilty of more than two crimes.
The double jeopardy argument, Your Honor, goes to the fact that because they had the lesser included on the, which is at page 104 of the record, of the resisting with violence, and this was all one ongoing event. Essentially, Ms. VELEZ was put in jeopardy once there. The jury found her not guilty of the resisting with violence, found her by implication not guilty of resisting without violence, and then the state got a second bite of that resisting without violence on the count 3. So my argument is that it was double jeopardy for the court, for the state to divide the charges the way that they did, particularly on the resisting with violence and resisting without violence. They got 2 bites of the resisting without violence.
They don't get 2 bites until there's a conviction, there's a judgment for two violations of the law, right? I mean,
well, my argument
isn't that what the decisional law says?
Yes, Your Honor. I'm not disagreeing with that, but what I'm arguing, Your Honor, is that by her being acquitted of everything on the resisting without violence, including the resisting with violence, which was count 2, including the lesser included of resisting without violence on count 2. She was put in jeopardy of the resisting without violence on that lesser included. The jury acquitted her by implication. Then the state went and got a conviction on a 3rd count, which was basically the same as the lesser included of count 2. So she was put in jeopardy twice for the same activity. This whole incident happened within a minute, within a very small area right in front of the car, with the same officer. The information charges is the same officer.
Do you have a case, Mr. Hernandez, that says that it might be a double jeopardy violation in a circumstance where a criminal defendant was only convicted of 1 count?
I have no case other than what I've cited in the brief. I believe those cases, and obviously
those are all common nucleus cases. I mean, and I understand that that if I understand your theoretical argument. I'm not saying I agree with it. That if she had been convicted as charged, there may be a double jeopardy violation. The remedy on appeal would be that we would order the trial judge to strike one of the convictions. That's what you get.
Well, let me ask you this, Your Honor.
What about if what about the circumstance where you're only convicted of 1 count? Do you have any case law that says that you should be entitled to a JOA?
I'm sorry. I have no additional case law with me today. I would ask. the point that I'm trying to make, and I'll try to drive it home this way, assume that the state had gone to trial on this case with just the battery and the resisting with violence, with the lesser included, and lost, acquitted. Could they then come back and charge her with resisting without violence in a separate case?
Well, you know the answer to that.
No. That's double jeopardy. That's essentially what they did. Each count stands alone, and the jury had to make a decision on each count. And so my argument is, when that second count, when they found not guilty, including rejecting the lesser included, the resisting without violence was decided by the jury. They then got the second bite, is what I'm saying. Mm-hmm. So that's the double jeopardy argument that I have.
Let me ask you to change gears just for a moment.
Certainly.
In your brief, on page 23, you talk a bit about the right to resist an unlawful arrest without violence, and which I agree is the law. I guess my question to you is, when we're talking about the right to resist an unlawful arrest, is it your contention that the arrest that was being resisted was the arrest of Mr. I think, was it Mr. Guzman?
Yes.
Brother-in-law.
Orville Guzman, yes, yeah.
Was she essentially going to his assistance in resisting arrest, or is it your contention in citing those cases that she was resisting without violence her own arrest?
The purpose of citing those cases was going to the argument, which also goes to Judge Torpey's question on the sufficiency of the evidence. It was disputing whether the officers were involved in the lawful execution of their duty. My argument is twofold. Essentially, it's both, although I'm not arguing in any way that she was going to the aid of Orville to resist an unlawful arrest. My argument is she was a deputy sheriff who shows up, and I brought all the facts out, Your Honor, to show that I'm asking this court to find that no reasonable jury would believe that a deputy sheriff is going to bring somebody to Orlando police officers and then interfere with them. That was the whole purpose, and that was all unrebutted evidence. And that's why I went into the great detail that I did, to show what happened and why she did what she did. And the fact that she's also, your suggestion that I'm just trying to get sympathy from you, I know you're not a jury, you're judges, and I'm not trying to do that, but it also goes to the unreasonableness of the jury's conclusion that a woman who's suffering, just had a baby, has excessive bleeding and cramps, is going to go in there and get into a fight with a police officer. She's just not going to do that.
Counsel, I understand all that, and you did a beautiful job in your brief.
Thank you.
I must commend you on it. But it sounds like most of those arguments are the types of arguments that need to be made, to the jury, not to appellate court as a matter of law.
I understand that, Your Honor. However, as I set out in my brief, and where that line is drawn, I know I read many cases where this court reverses on sufficiency of the evidence. Where that line is drawn, I guess, is something that I don't understand.
The difficulty is, as a matter of common sense, the argument that you made, and I don't know if you were trial counsel or not.
No, I was not.
The argument that was made below is, she essentially both encouraged this fellow to come back and accompanies him. And the idea that she would then, encourage him to come back and then interfere with the investigation does somewhat defy common sense, in my mind. On the other hand, when I look at the testimony, you've got two diametrically opposed stories going on here. The two versions, the officers' versions, the OPD versions, and the Guzman VELEZ version. And they're very difficult to reconcile. And it just seems to me, although I might have done something different were I on the jury, because I tend to agree that it just defies common sense. If the jury chose to accept, at least in part, the testimony of the OPD officers, what position are we in to essentially reweigh the evidence and just say, well, we wouldn't have believed it had we been on the jury? I mean, isn't that really what you're asking us to do?
No, Your Honor. What I'm asking the court to do, and I think the court's only, and it is a stringent standard, and it's a limited standard, is the court to find that under these facts, the jury's conclusion was not reasonable. And I do think that an appellate court can reverse when you make that finding.
Does that get you a new trial, or does that get you an acquittal?
I guess an acquittal if it's on the sufficiency of the evidence issue, as I understand the law, Your Honor. Now, in addition to the fact that you have it just doesn't make sense or logic that a deputy sheriff would go back and then interfere with fellow law enforcement officers, we have all of the issues occurring about how, after it happened, Toller admits that this is a high-profile case because he just tased a fellow law enforcement officer, how other officers go with him to help him prepare his report. And to me, the most disturbing is the fact that, and this probably goes on every day, and if it does, it's still wrong, that the state attorney gathers these witnesses in one room at the same time to prepare them to go to trial in front of each other. I don't see how that is not coaching a witness and not preparing a witness to testify, and I think it's improper. When you take all those factors and bring them together, I think that the court should have some grave concerns about what happened here, and given the fact that it defies, as Judge Offering, you just stated, logic and reason, that the court should find that it's an unreasonable verdict and reverse that particular conviction.
Well, what's our standard of review? I don't think we can just sort of disagree with the jury and reverse. Tell me what you believe our standard of review is in this.
I've set it out in the brief, and I understand it to be a stringent standard. Standard of review is you look at all the evidence in the light most favorable to the jury's verdict and decide whether a reasonable juror could convict. The court, as I understand what you're questioning, is focusing on the first part of that. You look at the facts based on looking at in the light most favorable to the jury's verdict. I'm arguing the last part of that. Decide whether a reasonable juror can convict. And I'm respectfully submitting under these facts.
If there's contradictory evidence on the issue, how can we do that? The jury gets to decide who they believe and who they disbelieve.
There is no contradictory evidence. It's totally unrebutted as to what happened before and the fact that Deputy VELEZ, at that time a deputy of the Orange County Sheriff's, brought her to the location.
So the jury disbelieved it. I mean,
well, I believe, Your Honor, based on all the facts, I'm respectfully submitting that that decision was unreasonable, and I'm asking this court. And I believe if there's any purpose for a sufficiency of the evidence argument, then I believe this is one of those cases where the court does have the discretion. I've addressed the double jeopardy.
You're down below your 3 minutes if you want to hold on to.
I'm sorry?
You got about 2 minutes and 45 seconds if you want to hold on to some time.
Okay. So I've got 2 minutes, 45 seconds to finish my first argument.
no, total.
Total.
Then
And I stopped the clock, so you're not going.
I'll wait for rebuttal, Your Honor. Okay. Thank you very much.
Good morning.
May it please the court. I'm Rebecca Wall, Assistant Attorney General, representing the state in this appeal. I think the record is
Let's make sure all Mr. Hernandez's points are covered here. How about the one about the bolstering? What do you say about that?
Well,
he cites a lot of cases there that all deal with closing arguments. Are they applicable in the circumstance where the prosecutor asks a question on redirect, or is that line of cases applicable here?
No, I don't think so, Judge Torpey. In fact, I think to characterize these questions as bolstering was really not, it mischaracterizes it.
Right. I know, I understand your argument there, but in a theoretical sense, those cases that he cites on for the proposition that the state can't, make those kinds of arguments in closing. Do they apply to questioning of a witness?
No, because the cases that deal with the prosecutor making those arguments in closing argument are true bolstering, where the prosecutor is vouching for and bolstering someone else's testimony, one of the prosecutor's witness's testimony. You should believe this witness more because they're a police officer.
The prosecutor's given his opinion.
Exactly.
or her opinion.
That didn't occur here.
Do you think he jeopardized his career as a policeman to come up here and perjure himself, those kinds of...
Right, and that's classic inappropriate arguing. What happened here was a very narrowly tailored question that was a direct response to the cross-examination by defense counsel. Not only the specific questions by defense counsel, but a very lengthy series of questions that clearly implied that the two arresting officers colluded, they rehearsed, they were lying. The whole line of questions about, you know, the code of silence, the wall of protection that officers, they have to rely on each other. It was very lengthy, and it attacked both of these two officers. These were the only two witnesses that the prosecutor asked this question directly. And the question was, in effect, are you lying here today? The answer is no. The defense attorney did the very same thing with the defendant when she got up to testify. And did you plead, what have you pled to these charges? Not guilty. Why? Because I'm not. I'm here to tell the truth. The offering attorney, while it might be tacky, superfluous, you know, common sense and clear, once someone's taken the oath to tell the truth and ask them on the stand, are you telling the truth? It doesn't violate, it's not bolstering, it's not inappropriate bolstering of someone else's testimony. So it's really not characterized correctly, and the prosecutor did not argue that in closing. Now, whether the prosecutor would have refrained from arguing it inappropriately in closing had there not been the motion in limine prior to closing, pointing that out, who knows? The fact remains there was not inappropriate closing argument that bolstered the testimony. There was no error in asking the questions. It was appropriate, very narrowly tailored. If there are no other questions, the State relies on its brief. Ask the Court to affirm the judgment and sentence.
Thank you.
In terms of the cases, Your Honor, I do believe they apply. I didn't find any cases that would talk about by cross-examination, but I think the question in the prosecutor's brief at page 9, the question was, so you indicated you like your job, correct? Would you jeopardize your career to lie for another police for another officer? I agree that the State would have had the right to ask some type of question, and the question that counsel just stated here would be totally appropriate. Are you going to lie for another officer? But when they start talking about and making the inference that you're not going to lie because you're a police officer and police officers don't lie, and that's the obvious conclusion from that type of an argument or that type of a question, that crosses the line. And given the fact that the evidence here, and you know, by evidence of the fact that the jury acquitted of the more serious counts.
All the cases you cite are closing argument cases.
Yes, Your Honor. Where
the prosecutor's vouching, giving personal opinion. Do you have any cases that say that that's a fundamental error when it's done in the context of a witness examination?
I'm hoping this is going to be one of the next ones, Judge. I could not find one, but I believe by analogy, which we do all the time, that's the rule. You can't do it. And I certainly think if you can't do it in an argument directly, I don't think you could do it indirectly by cross-examination. I believe that was the only point covered. I would ask the Court, there was also the issue of directed verdict. I'm on rebuttal, but may I address that very briefly?
Yes, sir.
The jury instructions, I mean, I briefed it in my brief, obviously, the issue of the prosecutor's closing argument she did. In fact, essentially, when you read it, I mean, I don't see how you cannot come to the conclusion that she was telling the jury. The judge is going to, says that they were conducting a lawful duty and that he is a police officer. The only thing you have to decide is did they resist or do something to oppose the officer. The law is clear that the jury has to make this decision on each element, and I believe that argument essentially was telling the jury the court.
That's what the instruction said, though, right?
Excuse me?
The instruction that the judge gave did say that, an Orlando police officer, all Orlando police officers are law enforcement officers, and in fact the standard instruction says the judge is supposed to make that determination, right?
The standard instructions say that the court can tell the jury that. The law is quite clear in the Constitution prohibits the Sixth and the Fifth Amendment.
So you're not quarreling with the instruction itself, you're quarreling with the way the prosecutor addressed it?
I'm quarreling with the fact that the prosecutor essentially told the jury, the judge has already ruled on two of these essential elements, you have only one element to decide here. That was wrong, that was a violation of the Constitution and the law. I would respectfully request that based on my arguments this morning and the arguments set out in my brief, that the court reverse Ms. Velez's conviction.
Thank you very much.
Thank you.
Thank you.